Thank you. Welcome to House General and Housing. It is Friday, April 18th, and we have returned from the floor. It's 10 of 11. We're going to hear two witnesses on H 334, which is an act relating to limiting employer restrictions on individuals separating from employment, particularly stay or pay clauses and non-compete clauses. Our first witness will be Megan Sullivan, who's Vice President of Governmental Affairs for the Vermont Chamber. Megan, you want to come and you're going to do both?
No, we're gonna switch.
Oh, okay.
On that first.
Austin Davis, Director of Government.
If you reload.
Uh-huh. If I reload. So thank you, everyone, for explaining my confusion. Austin Davis, Director of Government Affairs for the Lake Champlain Regional Chamber, would be the first to speak, and Megan Sullivan is the second. Austin, take it away. You want to introduce yourself?
Thank you, Mr. Chair. Yeah, for the record, Austin Davis, Director of Government Affairs for the Lake Champlain Chamber. Thank you for folks who are taking the time to hear from me on this rather important and complicated matter today. And I understand that this legislation, for the record, is subject to competing jurisdiction right now between two different committees. I actually kind of appreciate and to some extent welcome that, as this is a very complicated subject matter that is based off longstanding case law. And I actually think more eyes on this bill is probably better than less, especially with the limited amount of time that folks have. I think you could dedicate a whole session to kind of working on this. I've worked on this issue for about 6 or 7 years, and there's a rich body of case law with no statute. Actually, there's no statute. There's one limited annotation, and I want to say in Chapter 26 that it doesn't do much for it. So it's incredibly important to our state's employers and overall competitive advantage. I'd caution folks to take time while looking at this. So for the purposes of discussion, I'll break my testimony into the two components that are in the bill. There's the employee agreements around agreements to not to compete, and then there's the stay or pay provisions. And I'll start by saying though, but both of those provisions are, if used properly and judiciously, very important to our economy. And an outright ban of the non-compete component, it really is, from our perspective, not acceptable and overreaching. So we'd suggest, as I said at the outset, maybe delaying action on this, pushing this to the next half of the item where you can dive into all of the different uses that these agreements have. These agreements broadly, what they do is they prescribe for a set amount of time in a limited geography and in a limited scope of work what cannot be done in exchange for consideration or compensation. I actually think a good example of how these agreements play out is, you folks and members of the administration have a prohibition on lobbying within the state of Vermont for 1 year after you conclude your term. And, similarly, members of the administration have that. Now, this isn't necessarily a non-compete agreement. It's not titled that. It is an ethics agreement. And I'm not entirely sure what the enforcement mechanism of it is, but it is something that you've all agreed to at the onset of your employment as representatives in the state. And I think this highlights the importance of these agreements, where it's not just about proprietary information, excuse me, but also about ethical considerations. These agreements touch on intangible gray areas of employment that we don't necessarily have laws about. You folks don't necessarily have, proprietary information or trade secrets that you can go out and trade on after this, but you do have undue influence, and you do have, insider perspective that if there was necessarily a revolving door, could be, in your past colleagues, past legislatures have deemed, could be detrimental to your colleagues, to the state of Vermont, and to the institution as a whole. So there are other, other tools at the disposal of employers, such as non-disclosure agreements or trade secret laws, but they don't touch on those ethical areas, and they're harder to enforce. A non-compete is a very useful tool to cover the gray areas in between those tools and kind of interstitium there. So, I think Vermont small businesses, have to compete at a national and international level, and these agreements are really helpful to them to do that. Companies that build a business have the risk of competitors poaching their key employees, undermining their investments, and these non-competes allow for this ensuring the stable and fair competition. Often when we hear from startups, as some folks might know, we have the Launch VT Business Accelerator under our roof at the Lake Champlain Chamber. When these startups go out to find capital, to find initial investment, those investors, those suppliers of capital, whether that be a bank or a VC or someone else, they want to see that they have these non-competes in place to protect them and ensure that when they're in this small nascent stage, that just one or two key employees leaving doesn't scuttle the whole thing. And I think that's really important here, to think about. Some of these startups, they don't exactly have the secret sauce yet. They don't exactly have the trade secrets. They don't have, what they do have is an idea, concept that they're first out of the gate towards. But if we want to say some large out-of-state multinational doesn't have to compete with them, doesn't have to play with them, instead can just swoop in and poach one of their key employees, and that employee within 24 hours can be copying down everything they know about the concept and the roadmap to success. We're kind of cutting the legs out from beneath some of our Vermont small businesses and startups. So, I think on the other side of this, companies that are established, they invest time and money to train their employees. They take risks on employees that they bring them into the knowledge circle and share with them things on strategy, components of strategy and things like that, and mentorship that if a employee were to abuse that and leave immediately and go to a competitor, could be very detrimental. So we'd like to have you think about this legislation in the context of that, in the context of what does it mean for employers who are competing in a global workspace, competing with folks who I think many of you folks would like to see our small businesses triumph over, but it is very much a David versus Goliath. And many of those folks employing business practices I don't think many of us would condone. I understand you've heard from large out-of-state think tanks in support of this, and that checks out. I think the folks who are going to win legislation like this goes into place are large out-of-state companies who can now already were competing on an unequal playing field of Vermont small businesses, but now are not afforded, our Vermont small businesses aren't afforded the same equal opportunity to protect themselves under the law. So, with that, I think what I would ask is, are there examples or issues related to unreasonableness of, practices around non-competes happening in employment here in the state of Vermont that this legislation is addressing? Broadly, I haven't seen that, and I've been doing this role for quite some time, and this is a rather perennial issue. And Vermont has a very rich body of case law that covers non-competes and has proven to keep them reasonable and function. And the judicial system is a much better venue to deliberate these contracts, highly individualized. I think, do we have a question?
I do. Well, I acknowledge that obviously there's no law covering this because that's why we're looking at creating statute, but wouldn't you say that trade secrets are covered under the Title IX Commerce and Trade, Chapter 143 Trade Secrets?
As I said, I mean, I think trade secrets is one part of this. If you were to think of this as like a Venn diagram, what trade secrets and non-competes, they overlap to some extent, but there are things that non-competes cover. As I mentioned, kind of like some of the ethical considerations, some instances where there's not necessarily a trade secret at stake, but there's a knowledge base of, say, the landscape that a new nascent company is trying to build on. Those things are not covered by trade secrets. And so it's the gray areas, the areas not covered by either trade secrets or other tools that non-competes really shine and protect.
Do you think it's really possible to legislate either in the gray area or the black and white area ethical behavior?
I think you folks try to do that in many cases. I'm wondering if this body would see fit to remove your own ethical agreement that is to some extent a non-compete if you were to deprive employers of such a privilege as well. I think that's an important consideration.
When you talk about legislators having to wait 1 year before going to work for a lobbyist, what do you see as the difference in a 1 year time span? If a legislator went to work for a lobbyist after 1 year, what's changed?
I think I can't speak to the legislative intent of your ethics agreement that you're currently under. I do think Vermont case law has found 1 year as a reasonable timeline for as a provision of a non-compete. And as I said, there's rich case law around the reasonableness of different parts. Going back to the non-compete elements that you have in your ethics agreement, it is 1 year, a specific designated time. It is within the geography of the state of Vermont. You can go to New Hampshire and lobby before 1 year. And it is on a specific activity. They're not saying you can't, go out and actually even do anything you've gotten exposure to in the context of this committee and your time as a legislator. If you want to use, things you've learned about how labor practices are best practices, and say you want to go into an HR role, nothing's saying you can't do that. What it's specifically saying is you can't use, the privilege and the knowledge and the influence and everything else that came along with this job to then come back in here and, lobby your colleagues.
So what do you think changes after 1 year?
Like I said, I think at that time, in the context of your own specific ethics agreement that you are under, it's put enough time in between your actions as a legislator and your action and your work as a lobbyist. So maybe when your colleagues were passing that, their intent was probably around not having to question was the action that the representative was the impassioned for speech of the representative on the floor 1 week reflective of the fact that they went to work for a lobbying firm that cared about that 3 weeks later. It removes that kind of thing.
I would argue that instead of it being a non-compete ethics question, that it actually has more to do with the optics of legislating. If you are a legislator who pushes for a bill to get passed, which has money attached to it, and then you're hired in the position that the money was attached to, that's unethical. I don't necessarily think that it's a competition per se between being a legislator and a lobbyist.
So I think that's an interesting point, though. I mean, imagine in a private sector, you steered your company towards a contract that affected the company in X, Y, Z ways. And then, that contract seems to not have worked out well. And you, within weeks of that contract being signed, you jump ship to go to a competitor who actually benefits from the folly of your former employer. Then it's the same optics, same question is there.
It's not the same optics. We're elected officials. I mean,
I think this could be a committee discussion. I think we just need to remember that we're hearing testimony. And if we.
I'm just trying to draw a distinction between being a legislator and and working for a private company. I think they're two totally different things.
Absolutely, and I can understand that, but I think when we hear testimony, we should keep it to questions and then we can have committee discussion after.
Okay.
I appreciate the discussion, and there's certainly a different distinction. I think as I noted, it's an important consideration. They're very similar agreements, while they are under different titles and they have different types of work. And I'm happy to follow up further with conversation. I think that was pretty valuable. So where was I? There's a rich body of case law. So I think, we'd like to see you folks get a better understanding of that body of case law, what that covers, what has been found reasonable and unreasonable in Vermont case law around non-compete agreements. And then possibly, continue on with this conversation, potentially, and we'd be happy to work with your legislative counsel on this, codifying that case law. I could see value of having, the current state of play in non-compete agreements in the green books. That could be actually very helpful for folks. I also think that, there are other considerations that you could look into while doing that. There could be some language, and the Commerce Committee certainly has this language around prior notification of these contracts, potentially even in job listings. There's a possibility to look at how the courts deal with these. Some states allow for what's called blue lining or blue penciling, which is where they allow the courts to, instead of scrapping a non-compete agreement entirely, amend the non-compete agreement during the litigation process. So that is an option as well. But I think, as I said, I don't necessarily have heard of an instance where these agreements are being used in an egregious way. Everything to my knowledge is that they're being used in a fair, reasonable, and judicious manner in this state, and that the judicial branch, which is a co-equal branch of government to you, is regulating these quite well. So, we would suggest that you don't proceed with the legislation and this part of it as drafted. I'd also, just say that two things that generally will always kind of come in on legislation such as this, which is things like this can't be retroactive. Folks have built their entire business and their strategies around these agreements with the understanding that they would exist in perpetuity. To immediately upon passage of this bill nullify those agreements it creates a level of uncertainty and vulnerability to the business community at a time when we're already dealing with a lot of uncertainty and volatility from Washington.
Question about that. How do you feel about, instead of not saying that it's one approach is to say it's not retroactive, how do you feel about a delayed giving employers time to modify their non-competes?
I'd say it can't, if you're talking about modifying, then that means that you're open to the idea of not banning them outright.
Well, the legislation doesn't ban them outright. It has criteria in it, and other criteria has been provided and suggested.
So I think allowing time to modify could be something that could be useful. a lot of times actually, because of these contracts, one element of it is the timeline and the timeline being reasonable. If you push that far enough out, then eventually those contracts will be null and void anyway, because they'll run its course. So it might be, superfluous to even have a timeline to phase in and modify.
In that regard, I'm actually not that familiar with this. In that regard, are most non-competes that you have had experience with they expire after a limited time, and one, and two, is the case law sort of sketched out a period of time?
The case law has sketched out a period of time. I think one thing that is apparent is that all of these agreements are, very based on the conditions of employment, the conditions of the type of work, the compensation, et cetera. And there are a myriad of types of versions of this agreement too, that I think actually aren't contained in the statute or this proposed statute. So, but yes, generally there is an understanding in the case law and the judicial branch for what is reasonable. And there's cases where non-competes have been, as I can remember, have been vacated because the timeline was unreasonable.
Are we talking a year or 10 years? I mean, I have no idea what the range of case law has
Yeah.
emerged.
This is where I'm starting, part of being a chamber lobbyist is, being miles wide and maybe an inch, but a few inches deep. We're starting to get to the outer edge of my depth on it. I will say, while not an expert in this area, what I remember seeing in my experience with this is usually within the 1 to 2 year range, depending on the consideration that's exchanged. Yeah.
Can I just interrupt really quickly?
Please.
The longest non-compete that I have seen personally is 24 months. I think that's usually where the longest that I've seen.
And when you have those longer agreements, it has to be, it has to be backed up by like a bona fide business interest, a reason, and it has to be matched with consideration. These are not things that are looked at in isolation, all these variables. They're looked at all together, when the judicial branch is reviewing it.
When you
Go
say
ahead.
consideration, you're meaning, what does the person actually get?
Yes,
Like, who they can work for, or what's the package of?
the consideration would be their total compensation, or additional compensation that comes as part of the agreement. Sometimes you can have consideration be, after the fact.
Go ahead. I had the impression you wanted to comment on the stay or pay.
Yeah. Still, sorry, I'll wrap up my comments on the non-compete component. I think to just summarize, I think that these are important agreements. I think we should be very careful to have as our starting point codifying existing case law, and finding the actual deficits in existing case law, and having that be based off of evidence we've actually seen in our state and cases we've actually seen, because these are important agreements. They do help. I personally know that they do help, some of our nascent companies and, in novel industries that we are really proud of in this state. As I stated before, like I know that those folks trying to seek access to capital to make our state innovative, they're asked, and their backers want to see these agreements. And I think we should be careful, with the idea that's out there that, there are correlation and causation between certain areas not having these agreements and their perceived success. And there's a lot of different variables across the map that mean success. And, this is one of them, and this is something we actually have going for our community. So with that, again, happy to help with the process of trying to codify existing case law and understand what reasonableness would be with, as well as look at other components such as prior notification, And then maybe adjusting those elements as we see fit. However, I think we need to preserve these agreements. So I'll move to the stay to play or stay or pay restrictions. And kind of, and just really, I'll keep it brief with this, but again, I don't know if this is necessarily, I don't, a problem needs to be solved here. I'd be curious to know what this is chasing after. I worry that this adds undue complication and uncertainty that can spur litigation as well as unneeded friction to something that's really to some extent already working. And this could threaten retention tools or recruitment tools that our state has, in a very difficult hiring market. As standard employment practices such as sign-on bonuses, relocation reimbursements, training and tuition repayment, that are used and benefit employees are not happening through the state, and the state really needs private employers to step up and do these things. We don't want to compromise those things at all. We don't want to raise legal uncertainty. We don't want the reasonableness nature, the reasonableness that you folks inject in this bill, which is highly subjective. We don't want to have that defined by years, maybe even decades of litigation, when right now it's already operating just fine and to some extent defined. Without clear definitions, it might encourage employers from offering these benefits to employees, and we don't want to see that. So, broadly, I just say I don't necessarily know if we need to legislate around these provisions, and I worry that the any benefits of legislating this, these provisions might be outweighed by the negative impacts of doing that, the chilling effect it could have on our employment community.
I have a question and just a brief suggestion. The question is, if an employer offers a sign-on bonus, that's deductible. If the person leaves, let's say, too soon, within, a shorter period of time than some agreement provides, and it has to pay that back, is that deductible to the individual?
I wouldn't want to venture on that and provide you with an incorrect answer. I think I'd say, that is an important agreement. I've been in situations where I've had to offer both, sign-on and retention bonuses. And, the idea that we can provide that kind of bonus without can provide that consideration without them fulfilling their end of the contractual agreement, that's really scary. I mean, especially think about retention bonus. What's the point of a retention bonus if you can't retain the employee? That is worrisome. And I appreciate that the draft legislation envisions a pro rata basis. I think that also just gets us to a point where it just adds a lot of complexity, a lot of confusion to it. And it degrades the spirit of the actual agreement that is made when you sign an agreement on that type of bonus.
Are there questions before I make my suggestion? Yes.
Isn't it equal to what an acquisition cost would be? And is that something that's deductible for the employer?
I guess I don't understand what the fact of it being deductible or not deductible has. What the purpose
How
of
much
that
do they
question.
actually lose?
I guess it's not about what the employer loses or doesn't lose. It's about the provision of the contract is there to ensure, the contract is fulfilled. So that's like me saying, I hired you to to paint my house. And, you know, you get started, you paint half my house and then you disappear, but you gave me my money back. And you go, well, you know, what's it to you? You got your money back. I'm like, I got half a house painted here. I trusted you to do it for winter, you know?
Actually, it would be, and we didn't give you,
Yeah.
the person didn't give.
But you say, you know, it's a write-off. I'm like, well, it's still an awful lot of headache for me. And when I entered in this contractual agreement with you, you know, what I wanted was what I was counting on you for this. We had a deal. So I just think that the deductibility is kind of a red herring in this conversation. I mean, my employers are potentially standing there with, you know, the equivalent of a half a painted house and an employee that, you know, they may or may not be able to deduct the bonus they gave them, but they're still out quite a bit there.
My suggestion is this. We've taken testimony about really substantial, obnoxious abuses of both of these contractual devices. Applications of non-compete to beauticians or to people in the service industry, just because the employer feels like it, without notice. And applying even if they discharge the employee for no reason. They just want to discharge the employee and then turn around and sue them for the amounts. These abuses are documented in their national documents that abuse them. I doubt very much that any of us has the resources to do surveys in Vermont. There's a legislator who told me that she was forced to repay $10,000, was sued for $10,000 after being constructively terminated because of abuse in the workplace. But I doubt very much that this problem is going to simply go away because we don't have documentation that's specific to Vermont. So I do think your offer, I mean, and there's quite specific language that has been proposed to address some of these concerns, and specific language in other states. And I think it would be very useful and timely if you were to figure out what exactly would memorialize your concerns in words, in language, and to share it with us as soon as is reasonable. I don't really know the fate of these two bills, whether they'll move ahead now, in which case it would be quicker, or whether it's something over the summer, but I don't think it will just go away. That's my own perspective. And so I think your offer to help is an excellent one.
Yeah, and I you know, I fully intend to help. I would say that this is, we're looking down, you know, schedule. We've probably got about 4 weeks left in a typical session. I understand this might be a slightly longer session. I'm not necessarily certain that the amount of time we have in this session is appropriate to unpack such a, you know, complicated area of case law, not law, but case law specifically, if that we're going to try to translate into the green books. So I do think this would be more appropriate over the summer. Happy to convene my members and, you know, specifically HR and attorneys from my membership to look at this and try to develop something. We had done something similar a few years ago on, you know, this, which I can always kind of dust off some of that, but it'd be good to revisit it. So my ask would be that, you know, we punt this till next biennium, and I, in good faith, promise that I will be a partner in bringing something forward for next biennium that can suit all of our needs.
Yes.
I appreciate it. Thank you. I haven't served in this body forever, but I've been around. But can you refresh my memory, and maybe our next witness might know as well, but you mentioned that this has been a perennial issue. Is this every session? Has this kind of had a bill introduced, or has it been a minute? I can't remember.
It hasn't been every session. There's a bill introduced.
Usually,
You folks all know how it is. There's a lot of bills introduced. So every year I read,
thousands.
every year I read through at least one of these. There's been a couple years where this has advanced pass committee and
Oh, okay.
nominate through the other chamber.
Okay,
I think, in different iterations. And then, there was also, a time period there where there was some FTC discussion around this that didn't play out. So I think folks kind of said, let's leave it to the federal government to do.
yeah, no, I appreciate that. I concur with what our chair was saying. I think, this is gonna continue to come up, and I appreciate you being a partner. I think when we work with folks, it makes everything a lot stronger, and I'm definitely willing to be part of those conversations as well. I appreciate your testimony.
Yeah.
Thank you.
Yes,
And I think that the last thing we want to do is to discourage new businesses. And so, that was the most compelling part of the testimony for me about how this could pose a challenge for, startups. But I also know that there are a lot of situations where people, could move on and do something innovative, and we don't want to prevent that from happening.
No, I think I'd agree with your comments, Representative. I think every time you folks have had me in the chair, the motif is nuance. There's nuance to all of this, and I think getting at the right combination of tools, elements to something like this, to get at that nuance, it's crucial. I think whatever moves has to be really ready for prime time, and it has to have a very holistic picture to move and move towards, because we don't want to move with legislation just to find out that, we're losing VC dollars to Maine, which is already, much more beneficial. And that's something that your colleagues next door are going to have to deal with, the access to capital, report that ACCD wants. We don't want to see them that migrate because we passed something that has an oversight of it. And I think getting this right is really good.
further questions of the witness? Elizabeth, did you have a question?
Well, I just wanted to say that I think I can't remember whether it was 2 years ago or 4 years ago that we passed a bill in this committee that had to do with employees who had experienced harassment on the job at the state level. It was the Don't Darken My Doorstep bill. And 3 years ago, 2 years ago. And it had to do with employees of the state of Vermont who had experienced abuse or harassment at their jobs. There had been a non-compete agreement or non-rehiring agreement as prior to the passage of this bill. And in researching that bill and hearing testimony about it, the reason that I feel that non-compete is important is that what we heard was the degree to which if you have specialized training, or if you have a specialized circumstance of employment, it is very hard to get another job inside the state of Vermont in the same field. It's one thing if we were talking about a state that had lots of cities where you could float around from place of employment to place of employment, but we don't have professionals. We have a sparse employment scenario for specialized doctors. We have in all of the specialized fields that we have, our economy is based on full service economy and tourism. What we have outside of that is specialized is a very, very small job pool. We're not talking about, especially outside of Chittenden County.
You know what I think? Let's have these two witnesses and then let's have committee discussion. Okay? That's because I see a desire for discussion. Thank you.
Thank you.
And our next witness is Megan Sullivan.
Megan Sullivan, Vice President of Government Affairs for the Vermont Chamber of Commerce. Thank you for having me in on this bill. Generally, I will say, we are in agreement with testimony provided by Austin from the Lake Champlain Chamber. Have some concerns about the broadness of the bill and the broadness of the language. I won't sort of rehash the same testimony, but want to bring up maybe a few other issues and some of the things I've been percolating on, listening to this discussion. I think what was talked about in terms of codifying case law, one of the important parts there is when we come up with new language, new ways to think about this that aren't how the courts maybe already are, since we know that the courts are doing good work around saying what is reasonable and what is not reasonable, is making sure we're using the same terminology so that this doesn't need to have creating new case law where we're going to have to figure out what those boundaries are by going through lawsuits. So I think really important to do sort of that careful due diligence and understanding. And bringing in, I would, recommend bringing in attorneys who work on this already to talk about that, specifically of how courts look at this, what the language is, what the boundaries are that they're using, so that if it's something that the committee is looking at moving forward with it, that those are really important terminologies that get brought into play. We are very worried about the retroactive piece of this, that those agreements are put in place under the construct of current law. And so benefits are provided. Usually these aren't, you're not signing a non-compete without some benefit that you're getting for that. So understanding what happens to those benefits that you've been receiving for it, whether it's a higher wage or bonus for signing that, or if they're terminated, if you are giving up a certain severance package, understanding what are those contracts, bringing in some HR professionals. I know you have a great one on the committee already, but to talk about, if somebody has a non-compete in place, what are the details to be aware of that goes into that? So if it is, you're going to sign a year-long non-compete, and we're going to give you a year severance if employment is terminated for certain reasons. What are the ramifications of those becoming null and void that the employee may also have concerns with? I think in terms of the what's being termed stay or pay, have some just questions about the language in here. Again, a little concerned sometimes around how vague it is. Repayment that is reasonable. Who's determining what is reasonable? I think I can go into specifics here on page 5, line 8, subsection 1 under C. The employee voluntarily agrees to the provision in exchange for a benefit. I mean, that almost seems to be the definition of stay or pay. So if that is not, if those are exempt, sort of what's in, I would think in every case, the employee is voluntarily agreeing to the provision, and the benefit would be whether it's tuition assistance or whatever it is, the employee has voluntarily agreed to it. So question about what number 1 is referring to, what's included in that exclusion. And I did see that, now I've lost his name. One of the witnesses from last week provided some alternative language. So I've been reviewing that. And I think that does provide, it doesn't get in, I think it removes that first section altogether. Provide some clear language around tuition costs and but still some of those pieces, I think we need to look at it. How would this be interpreted? Is there, again, case law so that we're not making things like this get rehashed in the courts? But doesn't require repayment if the employee is terminated without cause. Who's determining cause? They're wrongfully terminated. constructively terminated. I don't think I've ever heard that term constructively terminated before, so curious what the
It's a term of art.
is it? Yeah, I don't know it,
I
but
think it's, yeah.
I think,
Okay.
sorry, I didn't mean to point to you this.
no, that's okay. I think my understanding is the reason that language is used is because there is a push to make at will employment null and void. And I think that's why that term was used in this bill, would be my assumption.
Mhm.
And I think it's intended to apply to situations where people leave because they suffered harassment or because they,
They could have taken all their resources to do their job away from them.
yeah, I mean, and it would effectively, because what happens is people are sued. If there's a stay or pay and they leave, and they don't, they're often sued in order to collect the stay or pay. And the question, and that constructive termination would be a defense. I left because I had to leave,
Well, this.
or because of the
They were
misconduct. of-
terminated, though. They didn't.
Yeah. No, they, yeah,
Okay.
but that's what constructive termination
Okay.
is. Just answering your.
Yes, I appreciate that. So I think, some further conversation, whether it's looking at this proposed language or the language that is in the current as introduced version of 334, that isn't in there, but I, especially that first piece, have questions of what that is referring to. I think more conversation is going to be important. I think with the sort of break while these bills were introduced the last few years, what the FTC was looking at doing this on a federal level, there hasn't been a lot of discussion. So my time in this building, I haven't spent as much time working on this as I know Austin has certainly been engaged in this in a long time. But I think, as this has come about over years, there have been these conversations about, what are ways that we can move forward in a path that does codify law. So maybe, I think someone had mentioned 2019. But it's led to me to have some good conversations with industries and bringing some of those industries in. Representative Burrows, talked about some of the areas where, should this be more tailored to specific industries where there is nervousness about abuse or under certain wage thresholds? I know is something that folks have looked at, that, for those higher level executives that are really working on certain areas, are these appropriate in high tech industries? Is there a difference in healthcare? I think bringing some of those fields in to talk about how these are used in their fields already, understanding what the sort of what is happening in Vermont around these provisions is going to be important. So we're not sort of doing something blanket to catch everyone if there are real differences in how industries are using these. I talked to one venture capital firm based in Vermont who said that all of their clients have non-competes in place, and this would be a huge challenge for them. And, their goal is to try and keep businesses growing in Vermont. And that can be really challenging with investment dollars. A lot of investment dollars are in New York and Boston, and part of, LaunchVT does a great job of launching incredible businesses, and curious how many try to get poached out of state with investment dollars based in New York and Boston. We want to keep them here and need to know what are the tools. Since, we're not growing the workforce that they necessarily need, any tool that we take away can create a challenge for allowing those industries to grow here. So I think those are going to be important conversations also to have around this.
Can I ask you a question that just kind of popped up through your testimony? Sometimes I feel like I shouldn't be left alone to my own thoughts because I haven't thought about this. So I'm going to ask your opinion of what this bill says. I think normally for myself, because I've worked in HR, I think of a non-compete between employer and employee. But non-competes have been used between employer and employer within the same area. I mean, I read through this bill. I don't think it's covered in this. Am I wrong?
Up a few doors down, there's another non-compete bill under consideration that specifically talks about between franchisor and franchisee. Though it's much broader than what you would think of as franchisor and franchisee. There's trademark pieces in there.
But I don't think this bill does, right? Yeah, sorry.
Sorry.
Phone a friend.
Yeah, the non-solicitation is kind of getting at that to some
Okay.
extent. And I believe, and there are a couple bills running about the building at this point. But there is, I believe in this bill, provisions allow for the dissolution or sale of the business in that instance. Which that could mean that, an instance of employee ownership or someone being promoted to partner where they do have ownership. That could trigger that then. So that is a component. The other thing I would say about business, just because we're on that subject, is I think there are what's sometimes described as naked no poach, which is agreements between employers that they will not recruit each other's employees, which actually are very detrimental to the employees, and they might not know that they're under such agreements. And it's worth noting that, folks often say, let's ban non-competes or highly restrict non-competes because Silicon Valley, they did it, and look how it turned out for them. And what's come up in evidence is that actually what's been in the background is these actually employer to employer agreements between the tech giants that have been at the expense of small businesses.
Okay. Thank you. Again, like I said, probably shouldn't be allowed.
Well-
My own thoughts, but I was like, I don't.
And maybe the second page, agreement not to compete means the agreement between an employer and employee that restricts the employee.
This one there.
Yeah, okay.
And I think Ledge Council Siegel wrote the the franchisor part in the other bill, and then Ledge Council here wrote this bill in the other part of that bill. If that's right, 205.
Thank you.
Anything else?
No, those are, we agree with, Austin, the Lake Champlain Chamber. I don't, need to rehash all of that again, unless you'd like to talk to me about it more, but wanted to bring up some of those other points that
Great.
I'm thinking about.
I appreciate both of you. And I guess since it's 20 of, I would like to allow a little time. This is not going to be the end of this by any means. But if members of the committee, I could tell we're itching to express themselves, and I want to
Oh,
give you
I
a
thought
chance to do that.
I was ordering my lunch.
Yeah, well, I am not proposing to intrude on your lunchtime
Thank
with the
you.
fact at all. But I did want to give people a chance. I know, Elizabeth, I cut you off. So I think people should say what they feel about this at this point.
Well, I was just looking, I think it was back in S103, which is the, when we were talking about that.
Harassment.
Yeah, so it was it was the severe and pervasive bill, but it also had a section, I think, do not darken my door.
Sorry.
Go ahead.
Please.
I believe that section was taken out. Maybe in the Senate. In my recollection is because one of the attorneys who represents employees talked about the financial bargaining chip employee to be able to increase the settlement.
Yeah.
Yeah.
If I might jump in as well, oftentimes in these situations, what the attorneys for the employees said is if you reach the point where you're considering such a provision in a settlement, you have just an employee-employer relationship that's just not reconcilable. And both sides see good cause to employ, such a provision. And usually, it's beneficial, it's a win-win for both sides because the employer gets some kind of level of like closure. We're not gonna have to bring this back, we don't have to worry about in the future, any kind of ill will or anything like that, or having to go through a hiring process with this individual again and have all of this baggage. And for the employee, they have the understanding that they can actually extract a higher settlement for it. So both sides, there's one of those rare opportunities where we had like Rich Cassidy and I can't remember the other attorney.
Oh, yeah.
A couple of attorneys, but they were in agreement. They're like, oh yeah, we love these, like these are great. So yeah, that's what came back.
What I was going to say was that, since that was part of the last biennium, we took a lot of testimony on it. That might be a good source for witnesses on.
Was that
this.
testimony and do you know what committee that was?
It was
In here.
Yeah, that's what I was right. Which obviously started in the Senate, but the other thing was that the example that was given was that state employees who had been harassed in one department, the state of Vermont being the biggest employer in our entire state. So if an employee is harassed in one department of the state with a non-compete agreement or with the do not darken my door thing, and the non-compete agreement, I think it was, that they can't get hired anywhere else by the state of Vermont, which is a huge,
Let's do not darken my door.
You can't work here anymore. You can't.
yeah, you can't get rehired by the same company if you've filed a harassment complaint.
I see. Okay.
Or by the same
Any,
employer.
whatever the complaint is, in the split, part of it is, you can't apply for everything, you can't apply
come
here
back.
anymore.
Yeah, okay.
So whether it was included in S-103 in the end or not, it would be a source of finding some good witnesses. And again, part of that whole, when we had that discussion, part of it was, we're not talking about a regular state, we're talking about Vermont, where our economy is divided into broad employment and really narrow employment. And there aren't necessarily jobs inside the state of Vermont. Yes, you could go over to New Hampshire but if you, like me, want to remain employed inside Vermont and keep your we always buy groceries inside the state of Vermont. We try to keep all of our tax dollars in Vermont, and that's just our family. But we don't want to have to go to another state to find employment because there's a non-compete agreement.
Other comments by members of the committee at this point?
I think that inevitably our focus is going to be from the employee's perspective, because that's the focus of our portfolio rather than necessarily from the business perspective. Or am I wrong about that? I guess I'm asking whether that.
I had always assumed, without giving it much thought, that our focus is to produce legislation that's fair to both sides and beneficial to the state.
Right, but is it important for us to gather testimony and get the perspective from the employees and then allow commerce to take on what the effects will be on commerce interests?
I had always assumed that by labor, it means both sides.
Okay.
I think any testimony that we take on anything, not just labor, we have to have testimony from both sides and understand the consequences.
So what distinguishes this bill from being our area versus commerce?
Just chance.
Oh,
Okay.
I think what happened is that I don't know exactly, the bill in commerce was proposed by the chair of commerce and written, I think they just followed different paths and
It might be because it has the franchising.
yeah, it might be that it went there. I'm
That
not
makes
sure.
it different.
But I do think they overlap enough that we should have discussions over the fate of all of this. If it may well be that the best thing to do is to spend some time over the summer, get it refined and try to deal with this before it comes back to us, them, et cetera. I don't know at this point. But I would appreciate any thoughts members of the committee have.
My impression is that there are some very real concerns and a very real possibility of abuses on both sides, whether it's employer or employee. So striking the right balance in a very functional and clear way is important, or we're just going to be revisiting the question over and over and over. So I think taking the time to craft it just right is important, or we'll be crafting it again.
That's for sure.
I guess my reaction listening was, I agree with Tom. I'm impressed by the abuse. I am concerned that the Department of Labor and the Federal Department of Labor and the federal FTC have issued reports and proposed rules on this subject because of the abuses. And that under the current administration in Washington, they will be not acted on, and consequently it will devolve to the states to address it. So I think there's a reason to address it. I am impressed very much by the narrowness of the Vermont market and what that does, as Elizabeth said, for the employee and the hardship of trying to find a job. I mean, this is not San Francisco where you can just go anywhere. Well, here I am, not there. And on the other hand, I think one of the big problems we have in Vermont, in so many areas, housing, for example, is lack of successful access to capital. And so I was very impressed by the idea that venture capital firms really want to see when they make agreements to invest, they want to see safeguards. And one of those is, to me, it seems entirely plausible that they would insist on non-compete agreements. And so I do think that this is something that legislature should successfully entertain rather than do it in a ultra-scale sort of manner. Yes.
I'd like to hear from venture capitalists themselves whether the reason they ask for non-compete agreements specifically is because of trade secrets or because of a lack of a labor pool.
Like a what?
Labor pool. I'd like them to answer both questions, and whether the trade secrets for them, for Vermont-based venture capital firms, whether the trade secrets chapter of law covers that.
Right. And I think specifically expounding on the testimony today, one of the things we heard today was that in fact, particularly young companies, their concepts which they're building have not yet, this is beyond my knowledge of the law, but they have somehow not yet matured to the point where they're a trade secret, but they are nonetheless commercially important. And I think you're right, a venture capital firm would be helpful there. Any other thoughts before we adjourn?
We could get that, what is it called? That development in Burlington.
Hula.
Hula. We could get the Hula guys coming.
That's interesting.
Innovation, they would address both.
Okay. Magali, at this point, let's just talk very briefly about Tuesday.
The agenda for next week is posted.
It's posted, great.
On Tuesday, we only have our public hearing
Oh,
from 1 to 3. Because you have the board, et cetera, in the morning.
Yeah.
from 1 to 3?
Well, that's
Wow.
what it's posted for. At the moment, how many people have signed up?
We're up to 9.
Oh,
Whoa,
excellent.
yeah, so 3 times 9, 27 minutes. That's half an hour of testimony. No, it'd probably be 40 minutes. Probably some soft-hearted chair will allow people to talk longer than they should.
Oh, I wonder who that would be.
Maybe we should have the vice chair.
Off-started.
Ah.
Chair.
I have the power to delegate running a hearing, you know, Joe.
I am well aware.
Yes,
I don't think it's actually legal under the First Amendment to limit somebody's time
it
to
is,
speak.
it is legal. But
Because
it
you
has
might
to
be
be
infringing
rational.
on everybody
It
else
happens
who
all the
wants to
time
be
in
on.
all of our hearings.
Yeah.
For example, the hearings that we had first of all, I know that just from my experience on various councils and boards, but also here, the Appropriations Committee has hearings on the budget every year and everybody has 3 minutes.
Oh, I know that it's a practice, a common practice,
And I think it though.
but I think under
You're right,
our
that
open
someone
meeting
could
law, it's
sue,
not.
well,
yeah.
someone could sue us. if There was no rational relationship between the time limit and the.
Yeah.
Yeah,
That's what I'm saying.
so, at the moment, that's all there is.
Oh,
If
great.
there's more, everybody, Monday, check the calendar, everybody on Monday, okay? Anything else? Great, thank you. We are adjourned.